Hello, everybody. This is John Miller, founding attorney with Rock Solid Law, and welcome to our first in a series of webinars regarding estate planning documents and strategies. The first one we want to tackle is the healthcare surrogate document. And the original title for this was, "What is a healthcare surrogate? And am I screwed without one?" We decided to change it to, "Am I at risk without one?" And the answer is decidedly yes. Even though it has a title that are not words that we typically use in our discussions with one another. Surrogate is not something we regularly talk about. It is actually a very simple thing to accomplish. And so at the end of these minutes together, I hope that you will understand better and perhaps that we can help you. So I also, for those of you that may see this on a recording later, we are currently in the middle of the COVID-19 coronavirus pandemic crisis. So I hope that everyone is practicing social distancing and enjoying your obligatory solitude. I found that we can accomplish a lot during this time, but that we may need to refocus some of our energies and efforts. I know that all of us are doing our very best not to need medical attention during the pandemic. But the question arises, what if we do? Obviously, those who are infected with the coronavirus are going to be in the healthcare facilities, the hospitals, emergency rooms, and other places. So what if we have to go there? Obviously, we're placing ourselves at a higher risk. And my answer to that is, if we found ourselves in need of medical attention during this time, we would not want to go it alone. I think it's a good goal in life not to go it alone, but particularly during this time, we would not want to go it alone. But everybody, I think, knows that admittance into any healthcare facility, particularly a hospital, is very limited, particularly at this point in time. So if we needed treatment and we were not able to help ourselves, we need to appoint someone to speak for us. The healthcare surrogate or medical power of attorney is the legal document that allows someone to step in and care for you when you can't care for yourself, when you can't make decisions for yourself. Now, doctors and healthcare providers, as we've seen in this time, are heroes. Always, but especially right now. Our individual healthcare, however, is really the responsibility of each one of us. And we need to be sure that someone is legally appointed to step in to help us out when we cannot help ourselves. Doctors take a Hippocratic oath. Hippocrates historically was in the early Greek democracy, of course, over 2,100 years ago. And he was one of the early physicians, and therefore the oath that doctors take is named after him, the Hippocratic Oath. Essentially, a Hippocratic Oath is that a doctor is supposed to use every means at his or her disposal to keep us alive. That can play out in some very awkward situations so that we are being kept alive past the time when some of us would make a personal decision that we no longer wanted to be kept artificially alive. I have so much respect for doctors, physicians, and healthcare workers, especially during this pandemic. They are doing heroic acts every day. I myself may have chosen to have been a physician, but my high school chemistry class pointed out to me that my aptitudes were not necessarily in the higher sciences. And my high school biology class let me know exactly how squeamish I am when having to deal with a frog and not very much enjoying the squishy parts. So instead, I became a lawyer, and one of the ways that we are helping out, I will discuss at the end of this video during this pandemic, and also just for your either attending live today, or even if you watch this on the replay at the end of the video, I will let you know some valuable information that will be helpful to you and will save you money, including a free offer. So listen, a healthcare surrogate is simple. It's where we appoint someone to take care of us when we're unable to take care of ourselves. It's often called a medical power of attorney. It can discuss someone acting for you as your proxy. People may discuss it in terms of someone acting as your fiduciary rather than surrogate. Particularly, many Floridians come from other states. The terminology state to state can be quite different, but just think of it as the person who you appoint to take care of you in the event that you're not able to make decisions for yourself. So what do you have to do? You have to first pick the single person in the whole world that you would like to take care of you if you were in a medical crisis and could not make your decision yourself, could not take care of yourself. I'm sure someone just came to your mind, but I want to also give you some other things to think about. Remember the practicalities of the situation. Really, in my opinion, a healthcare surrogate needs to be someone who is immediately available. They need to be more or less on call when and if that emergency ever happens to you. Is it a good idea to pick somebody that resides in your town or city in Florida? Is it a good idea to pick a child of yours who might be perfectly willing and able to travel to be with you during that time? Now, during the pandemic, when people are not being admitted to be with their families, the distance requirement might be lessened. So it might be a different person during this time than it would be in more normal times in your life. So think about who that person is. Might be a spouse. It might be a child, a son or a daughter. It might be another relative, or it may just be a trusted friend. After you've chosen that person, then pick an alternate. Who came in second in your mind? Who is the second most qualified person in your judgment to take care of you if you can't? Now, the information you'll need to actually prepare the power of attorney appointing a healthcare surrogate is as follows. Their name. You might put their first name, middle name, nickname in quotations, and last name. But we need a full name. We'd like to know the relationship to you. Are they related by blood? Are they kin? Or are they a trusted friend? We need their address. It's okay if their address changes. This information is so we can get in contact with them. We'd also like to have their other best methods of contact. Certainly a phone number, maybe an alternate phone number. What about an email address? That sort of information is vital because we need to get in touch with this person. Someone will need to get in touch with this person absolutely as quickly as possible in the event that you do have a medical emergency, such as having to be hospitalized, testing positive for COVID-19. All right, after the form is filled out with name, relationship, address, and other contact information, phone numbers, email addresses, then the form needs to be signed and dated by you. You will need two witnesses, and it's best if they are unrelated to you and also not the people you chose to designate as your healthcare surrogate. Underneath the witnesses' names, we would ask you to print their names so that it's legible. Now listen, particularly during this epidemic crisis, there are a couple of things I want to discuss with you. One, we're going to add, if Rock Solid Law prepares this for you, and we would recommend wherever you were to have a healthcare surrogate prepared, we should add language which would allow your surrogate to give instructions by telephone, by video means, and also by email, by an online conference, any method possible, because sometimes visiting the physical facility, the hospital, is not possible right now. So we want to make it as broad-reaching as possible during this period of time. Once the crisis has passed, we may want to re-examine this, and you may choose to take that language out of your healthcare surrogate document. Additionally, if you have any documentation in place which has a prohibition against intubation, we would recommend that that be removed. Obviously, from the news, one of the ways to keep patients healthy or to return them to health during the COVID-19 is through intubation. That might be found in a healthcare surrogate document. It also might be found in a living will if you're trying to check to see whether you have something existing that discusses intubation. All right, what if you can't get two witnesses during the crisis with so much social isolation, with so much distancing? Maybe that's a difficulty for you. We recommend signing a document anyway. It may be that those are ratified by a later law, and it's better than not doing it. Then we would have a separate, another copy of the same form. And we would ask you that at the earliest opportunity where you are around two people, two adults, 18 and over, hopefully they're not related to you, but again, best practice, get it done. You go ahead and re-sign it, redate it with those two witnesses signing along with you. Now, the very best practice of all is to have this document notarized. But we know particularly during this time, that is not available to everybody. It may even be inadvisable to break your social distancing to go get the document notarized. So we are recommending, particularly at this point in time, that you execute the document and get two witnesses, even if you do not have a notary available to you. Of course, Rock Solid Law is available to notarize the document. Unfortunately, not until July 1, 2020, can estate planning documents be notarized remotely through video conference. Other documents can. I have contacted the governor of Florida through his staff to ask that they move that July 1 date up to now so that we can serve Florida families and get their documents executed. To date, the governor has failed to act. Governors in other states, New York is one example, have taken this measure. It's common sense. I can't imagine who would be opposed to it. But as of yet, the Florida governor has not acted. So we are not able to do remote notarization on estate planning documents like we can, for instance, on the closing of a real estate transaction and other documentation. So best practice, two witnesses and notary, particularly during this time. We recommend getting it signed, doing the very best you can to get as much of that procedure followed, but not procrastinating to wait for your witnesses. Sign it at your earliest opportunity. Now, what do you do with the document after you've had it signed? One, you want to have your lawyer have a copy of it. They'll keep it on file for you so it's available should your family or your surrogates need it. But particularly, get a copy to your general physician and any other doc that you see regularly. If you are generally treated at a specific hospital, it's a great idea to get that healthcare surrogate on file with the hospital at your earliest opportunity. Of course, do it safely. And then create a folder that has your healthcare surrogate in it. It may have any other documents, like if you have a living will, in that folder. I recommend doing it in a bright color, one that's easy to find in your home, and place it in a place where you and your surrogates both know it is, just in case you need to have treatment. You take that folder with you. Give a copy to each of your healthcare surrogates, your healthcare surrogate and the alternate, so that they have a copy of it and can present it. Now, I think it's important, since this is an educational webinar, that we let you know what a healthcare surrogate or medical power of attorney is not. A healthcare surrogate only allows the person you designate to deal with healthcare providers. It is not a durable power of attorney, and it is not any other of a specific power of attorney granting other powers, meaning the person you appoint as healthcare surrogate cannot do other things for you. There's a different power of attorney that would allow, for instance, someone to deal with your bank for your business matters. The healthcare surrogate document does not do that. It is also not a living will. Our practice at Rock Solid Law is to have a healthcare surrogate and a living will executed in separate documents. Some fine practitioners combine them. So the healthcare surrogate is not a living will. Very quickly, and maybe we'll do another webinar on this, a living will is what I call your ticket to ride. It is your pass from this life into the next. It is the instruction to your healthcare providers on how you wish to be treated during your final illness. We can talk more about a living will later, but please know that the designation of healthcare surrogate is not a living will. Now, your healthcare surrogate may in fact interact with your healthcare providers, your doctors, your nurses, whoever else, in respect to the wishes you have set forth in a living will, if any. They may be able to discuss it, and of the whole world, the healthcare surrogate is the one person who should be able to discuss it with them. But your healthcare surrogate should not be able to override your wishes as stated in a living will. I want to let you guys know that as a reaction to the pandemic, for this month and perhaps beyond, we'll have to see how the curve is going, how the peak is, how we're able to shorten what's happening. We are offering any Floridian a free healthcare surrogate document. We will help you prepare it and provide it to you to take for signature at absolutely no charge. We're waiving our fee for that. And so far, we have helped over 30 families at absolutely no charge. I'm very proud of my team, my staff, for helping me to help others during this period of time. Secondly, for staying to the end of this webinar, we would like to offer for you to have a consultation with us where we can answer specific questions about your estate planning generally. It would include healthcare surrogate if you liked, or all of the other things that have to do with planning your estate, sharing your love to those you treasure, perhaps some tax savings plannings, all those sorts of things. We will waive our consultation fee as a show of gratitude for your watching this video or participating with us live this morning. That's a $425 savings to you, and we would be happy if you were to choose us to help you on that journey. I want to close with letting you know that we are committed to providing the safest, smartest decision you can make right now in respect to working with us. We are keeping a very sterile atmosphere in the office by the few employees that are still working here. Most of our people are working virtually at this point in time, and provide a conference space that is repeatedly cleaned so that you can feel comfortable sitting there if you choose to have a face-to-face discussion. And we are sitting across the table and away from each other during this time. We also would offer you, obviously, because we're participating on one today, a video conference where we can be face-to-face and interact with each other in a discussion about your estate planning needs. Or finally, of course, we can do a consultation over the telephone, the old-fashioned way, which I've been doing repeatedly during the pandemic. So glad to be here for you in any way to make it as safe and smart as possible. We hope that you will make the smartest decision for you in regard not only to your healthcare surrogate, but the other needs that may be specific to your life that you have during this time and going forward. Thank you so much for being with me on this webinar. We will be doing a continuing series at 9 o'clock on Thursday mornings, certainly through May, and addressing a different estate planning topic each week. If you have a topic that you would like for us to discuss, please submit it, and we will take that into consideration in choosing our future topics. I wanted to let anybody know we do have a little more time. If anyone has a question and would like to submit it on the chat is located at the bottom of the Zoom window. You could type a question in now, and I will be happy to answer that. I want to let you know next week's subject. We will be talking about the appointment of a temporary guardianship for minors. What if you woke up and you were infected with COVID and had to go into complete quarantine and were not able to take care of your children? Who would do that for you? It's very, very important to get that temporary guardianship affidavit executed in advance so that someone would be legally entitled to step in and take care of your children in the event you couldn't. Really important subject that I hope you will join us on. Well, I'm not seeing any questions at this point in time, so I must have thoroughly covered the subject matter. I hope so. If you are watching the playback and you have any questions, please feel free to submit them to questions@RockSolidLaw. Oh, I see we do have a raised hand. Let me see if that is a question. Ma'am, did you wish to put a question on the chat board? If you do, please do so. Otherwise, please submit that question to questions@rocksolidlaw.com. Questions@rocksolidlaw.com. I see there is a question, so we'll address that one. What's the difference between a power of attorney and a healthcare surrogate? That's an excellent question. A healthcare surrogate actually is one form of a power of attorney. There are many, many, many different purposes that a power of attorney can serve. It is essentially a document through which you appoint someone to act for you, either for a specific or a general purpose. So the actual answer to the question is the healthcare surrogate is a power of attorney, and that person has been appointed to act as your fiduciary, just as a fiduciary under a different type of power of attorney would be able to act. Are there any other questions this morning? Thank you for submitting that one, Amy. It's good to see you on here. Thank you for participating this morning. Anyone else who would like to ask a question? All right, well then please submit your question to questions@rocksolidlaw.com. Thank you so much for participating this morning. Again, we are waiving the fee to prepare healthcare surrogate documents for all Floridians during the pandemic. If we can assist you, please let us know. You can write directly to Shelley, and that is spelled C-H-E-L-L-E, Shelley at rocksolidlaw.com. You may also submit to questions@rocksolidlaw.com. Thank you so much. I'm John Miller, founding attorney at Rock Solid Law. It's absolutely a pleasure to be permitted to discuss this matter with you this morning. I hope that it has been informative. I hope that you get some good information about it, and I look forward to helping you or someone you know and love in the near future. Please stay faithful to social distancing. I really hope that you enjoy our obligatory solitude and get some things accomplished in your life that you might not otherwise have. Thank you so much. John Miller saying take care of yourselves out there. Bye-bye.